In this video, we'll learn defamation. Most tort liability cases involve claims for damages that are physical or mental injuries. But if people's reputations are damaged, they can claim injury and be awarded damages for written or spoken defamation. There are two terms related to defamation: slander and libel. Slander refers to spoken defamation, including sign language. Libel refers to written defamation, including pictures, videos, and conduct. There are four things to determine whether defamation has occurred. Courts take into consideration these four factors. First, whether the targeted individual was a private person or a public person. Second, whether the communication was true or false. Third, whether the expression was an opinion or fact. And fourth, whether the comment was privileged or not. First, to file a claim against the individual responsible for the alleged defamation, that individual has to be considered as a private person. Who are considered as public figures or public officials? Public officials are those who have substantial control over government affairs, such as politicians and school board members. Most of the courts don't consider teachers as public officials. However, some courts consider school administrators and coaches to be public figures or officials. Second, a defamatory comment needs to be false. Educators must avoid making comments in bad faith that will result in liability. Third, a defamatory comment is a fact. Most opinions are protected by the Constitution, particularly when public figures or officials are involved or the issue is one of public concerns. What is an opinion? It needs to meet two criteria. First, the communication must not be proved as true or false. Second, the communication must be considered a personal perspective on the matter. It is a factual statement if you say, "The school principal stole school funds." The statement may qualify as defamation unless it is proven true. Fourth, if a communication qualifies as privileged, then the defamation is not supported. Privilege is a special legal right or immunity granted to individuals. Privileged communication is an interaction between two parties in which the law recognizes a private, protected relationship. Whatever is communicated between the two parties must remain confidential, and the law cannot force their disclosure. Examples of privileged communication include the interactions between attorney and client, between priest and parishioner, and between two spouses. Both absolutely privileged and qualified privileged communication have been supported in courts. Statements that are considered absolutely privileged cannot be served as a basis for defamation under any circumstance, even if they are false and result in injury. Absolutely privileged communications occurs when school officials' statements are made during informal judicial or administrative proceeding. This defense has been applied in cases involving superintendents and school board members. School board members' statements about a district supervisor at a school board meeting were considered absolutely privileged by the North Dakota Supreme Court. A high school student died while participating in a football game. At the student's death, the required physical examination had not been performed, nor had parental consent been obtained prior to the student's participation. After an investigation of the incident, the superintendent issued several letters of reprimand. One of the superintendent's letters asserted that the head football coach failed to follow the required rules and regulations for the operation of the interscholastic athletic program at the high school during his tenure as varsity football coach. However, the letter made no mention of responsibility for the student's death. At a press conference, the superintendent stated, without specifically naming any individuals, that she would officially reprimand each member of the coaching staff who had not followed the required procedures. The head football coach instituted a defamation action, alleging that superintendent's statements were false and defamatory. The court held that the superintendent enjoyed absolute immunity and that the superintendent's letter and statements were made in the course of discharging her responsibilities. Qualified privilege has been supported in courts as well. To be considered as qualified privilege, a communication must be, first, made in good faith. Second, on the subject matter in which the person making it has an interest or in reference to which he or she has a duty. Third, made to a person or persons having a corresponding interest or duty, even though it contains matter which, without this privilege, would be slanderous. And fourth, made without malice. In education, what types of communication have been considered by court as qualified privileges? Administrators' ratings of school personnel has been considered by courts as qualified privileges. In a defamation case in Pennsylvania, a school principal rated the vice principal's job performance as unsatisfactory, described his performance as inept, and categorized the vice principal as insubordinate and inattentive. The superintendent signed the job evaluation and recommended the vice principal's employment should be terminated. In a public hearing regarding the vice principal's employment, the principal testified the vice principal's job performance was inept and unsatisfactory, and a school board member commented that the vice principal was grossly insubordinate, if not incompetent. In this case, the court concluded that the alleged wrongful actions taken by the school principal, the superintendent, and the school board were within the scope of their statutory duties under the school code. Here is another case. In New Jersey, teacher A and B from two different schools took students on a trip to Spain. After the trip, teacher A wrote a letter to the principal of teacher B's school complaining that teacher B drank 7 bottles of wine on the plane and acted unprofessionally by keeping students out until 2 or 2:30 a.m. Teacher B filed a defamation complaint against teacher A. The court concluded that teacher A's letter was not defamatory, and also noted that teacher B had no alleged pecuniary damages, including loss of earnings and grievous mental injury in that she was exposed to contempt and ridicule of her friends and acquaintances, and was rendered outraged in mind, spirit, and body to the extent that she required prolonged medical treatment to restore her health. The court noted that in teacher B's deposition, teacher B stated that she was neither fired nor suspended from her teaching position and that she did not suffer any economic damages. Here is a recent defamation lawsuit. In May 2021, a New Jersey teacher, who was also the secretary of the teachers' union, filed a lawsuit against the interim director of facilities for his school district, alleging defamation and false light. The teacher called into a school board meeting via Zoom in August 2020 and complained about the conditions in the school. The interim director of facilities was called into the next board meeting in September 2020 to refute the teacher's claims. In the meeting, the interim director of facilities questioned the teacher's honesty and suggested that he had another agenda. With what you've learned about defamation and the 4 factors of defamation, do you think the defamation has occurred?